Well, here's another one which is really kind of related. It's the Hocutt versus Minda Supply decision by the Appellate Division. And this deals with this concept of a special employee. Now, this case involves somebody who stupidly got onto a forklift and rode on a forklift that was being operated by the regular forklift driver. He's kind of hitching a ride. And just that practice by itself is just forbidden by OSHA and the relevant New Jersey regulations. I mean, this is not something that's supposed to transport human beings except for the driver who's moving things. And I take it from reading the facts of the case that this guy was really badly hurt. You agree?
Oh, it sounded like what he required is skin graft and 4 surgeries to his leg. So, you know, he was basically on the riding on the back of a forklift, and his co-employee inadvertently backed the forklift into an I-beam. That just sounds like it hurts.
Yeah. So the key is, was this guy an employee of Minda Supply or not? If he's an employee of some kind, then he's entitled to workers' compensation. If he's not, then he's got to sue the manufacturer of the forklift, I guess. But in the meantime, what is the situation with his status with Minda Supply? Why was he or was he not an employee?
So here's the bottom line note, just to back up for a second. He would have sued. He was suing the place where he worked for negligence. He didn't have to go. So he was trying to argue, I was not an employee. I worked for the leasing company, and this third party caused my injuries. So, which is what, in the context of the personal injury world, these are the cases, but for this issue of him being a special employee, these are the cases that attorneys are that are good for a personal injury attorney. You have a good workers' compensation claim against the employer, and then you have a claim against the third party who's at fault for what negligently caused the injuries. And that's what I think was the plan of Mr. Hocutt at the time. There's an exception
but
because he's a special
the
employee.
employer is saying, listen, you can't sue us. Your exclusive remedy is going to be through workers' comp, right?
Exactly. I'm just explaining the context of how these cases typically work. Think of the New Jersey Transit case. You're an employee, you're in a car accident, you get your workers' comp benefits, and then you sue the person who caused the accident for pain and suffering. Because in workers' comp, you don't recover pain and suffering.
Right.
So it's a much different case. So they brought the claim as a negligence claim against a third party, and then they had to shift to the argument. So the defense was, well, you're not a third party, you're our employee, you're a special employee. And it's a 5-part test that is used to determine whether there's a special employee relationship.
So let me just talk about just the facts of this case. Was he a member of like one of these places where you need temp employees, basically? So you go to a temp agency and pay them and they send somebody over. Was that basically what this guy was?
In some respects, yeah, it's an employee leasing company. So yes, but the difference or one of the distinctions they make is that Mr. Hocutt had the right to say to the leasing people, I'm not going to take that job. But he took this one. And that the court seemed to put some weight into that, as that made him. So the 5 steps are: the employee has made a contract of hire, express or implied, with the special employer. And they treated the fact that he had the right to turn down the job and instead it took this job as his implied consent to be their employee. I think it's a little bit of a stretch, but that's the way they went with that. The work being done by the employee is essentially that of the special employer, without question. He's doing the work with the forklift and they control it. And then the third one is the special employer has the right to control the details of the work. 4 is the special employer pays the employee's wages. Number 5 is the special employer has the power to hire, discharge, or recall the employee. So if you are considered a special employee, then you're exclusive remedy is workers' compensation. And here, the staffing agreement that was entered into basically said that that Minda, the employer, would reimburse Express, the leasing agency, for wage payments by agreeing to pay the charges based on the time card or other mutually agreeable recording method. The agreement also said that that Minda would supervise, direct, and control the work. So based on those factors, the court concluded that the exclusive remedy was workers' compensation. And then we get to the second part of all of this, which is the other piece that comes into play. So Hocutt, the plaintiff, said, well, if workers' comp is the exclusive remedy, I have a second argument to make. If I'm a special employee, then this was intentional and reached the level that because it was an intentional wrong, workers' comp is not a bar. And what they missed with that, or the reason why that didn't hold, is that it's not just negligence or reckless conduct. You have to almost show willful indifference in order to get around that workers' comp exclusivity. And the court says, as it's explaining this, the quote they said was, the line between negligence or reckless conduct and intentional wrong must be drawn with caution. Otherwise, the workers' compensation remedy would be circumvented simply because a known risk later blossoms into reality. So in other words, there were OSHA violations. They shouldn't have been riding on the back of the forklift. But even with all of that, it wasn't foreseeable that this type of an injury was going to happen. And there was no substantial certainty that he was going to suffer this type of an injury or be injured. So based on that, they just thought it didn't rise to the level of intentional wrong as it's laid out in the case law on workers' comp.
So at the end of the day, all he's going to do is wind up getting workers' comp, right?
Yes.